so that when you have a lot of people coming to our nation, either by canoe or whatever, we used to make sure that the security of the communities at hand, but also to make sure that the guests that come into the community are feeling welcome, fed, and looked after, so that they can carry on with their own journey. But with this, I just want to say it again. Thank you to our university, and thank you for the folks that are joining us for sharing in a way that our people have handed down for centuries. And I just want to say welcome to our Lekwungen territory. Aichka. Have a good day.
Thank you, Dr. Skipdick. You begin our work together in a good way, and we really appreciate that. I'm now honored to introduce the co-chair for this session, Dr. Kimberly, who's somebody who I've known and admired for a long time. We've had a chance to work together over the years. She is currently the Assistant Deputy Attorney General, Indigenous Justice for the province of Ontario. And she was the former Executive Director of the TRC, the Truth and Reconciliation Commission of Canada. She is from the Kanehsatake Mohawk Nation. Kim?
Sego Seguego Skinagoa, Kimberly Murray Yungat, Skanyega Haga Kanehsatake Wakwoho. I'm joining you today from the Dish with One Spoon Treaty Territory and from the city of Toronto. I'm really honored to be here today and to be a co-chair with Dr. Napoleon. And I want to say Nawe, thank you to Dr. Skip for his opening Thanksgiving. And Val, before I pass it back to you, I just want to say that I think on behalf of everybody that's probably watching this conference today, I just want to really acknowledge the work that you have done over the last number of years and what the University of Victoria has done to lead the path for practitioners in revitalizing Indigenous law. So I would be remiss if I didn't acknowledge you for the amazing work that you've been doing. So now, and I'll pass it over to you.
Thank you, Kim. So I'm Cree. I'm from Saulteau First Nation in Northeast British Columbia. And my name in Giksan with the Northern Frog House of the Gitniao, my name is Gieks Gun. And thank you, Kim, for those words. And you know, this time, this is the fourth of our series of conversations, national conversations that we've facilitated, that we've set up, and there's been a huge response across Canada, and it just demonstrates that there's such a hunger for these kinds of conversations and for the space in which these conversations can happen, between Indigenous scholars, between allies, between thinkers coming together, you know, and drawing on work and experiences from over the years. So, you know, these, we've called them these national next conversations. We've centered on legal education, we've centered on revitalization and the practice of Indigenous laws. And so there are so many important conversations to have, and that need to still be facilitated. So today, what we're looking at is Indigenous laws and practice and institutions, and Canadian laws and practice and institutions. And we're really wanting to draw on the experiences of the people, our panelists who are joining us, to think about what is that interaction across Indigenous and non-Indigenous legal orders. What's the kind of engagement that when we think about laws, when we think about practices, when we think about institutions, what's going on? So we have panelists who will be introduced to you in just a minute, who work on advancing all areas of justice. And they're advancing the rights of the communities that they work with as well. So if you have some specific questions as you go through this session, as you are able to listen to the discussion, please share them in the Q&A function, which is at the bottom of the Zoom window. And we have a team of people from UVic, and they're going to be posing the questions or passing the questions that you raise onto myself and onto Kim. And toward the end of our session today, we're going to have an opportunity for people to ask the questions and to have some discussion with our panelists. So we have an agenda. The topic, as I mentioned, is about these complexities, about the current legal landscape. So we're going to have 2 discussion periods. In between that, we're going to have a short health break and then an opportunity to open it up for participants to join us with questions and answers. So that's the lineup. That's the work we're going to do here today. And I look forward to hearing everyone speak, and I look forward to questions that we're going to get as well. So Kim?
Thank you, Val. So I have the great honor and privilege to introduce the first panel, and I'm going to do a short introduction of the individual panelists. And I know that everyone has the bio, so I'm just going to touch on a short information about each of the individuals. And I'm going to invite each one to say a few words and introduce themselves and how they would like to introduce themselves. So the first I'm going to introduce is Chief Leah George Wilson. And Chief George Wilson was the first woman to be elected chief of the Tsleil-Waututh Nation in 2001. She served 2 terms before going to law school, and she was also the director of the Treaty Lands and Resources for 9 years for her community. So I welcome Chief George Wilson, and I invite you to say a few words of welcome.
Good afternoon. So happy and privileged to join all of you today. Thanking you for having me. And incidentally, I served 3 terms, and I'm currently in my 4th because these kind of jobs are hard. Thank you.
Thank you, Chief George Wilson. Next, I'm going to introduce Krista Big Canoe. Krista is the legal director at Aboriginal Legal Services in Toronto, and she's the former lead counsel for the National Inquiry into Missing and Murdered Indigenous Women and Girls. Welcome, Krista.
Good afternoon. Wino Bujo, Wino Gishagab, Krista Big Canoe, Nadishna Cause, Noden Kwa, Nishnabe Kwe, Nagig Dodum, Owasiegamak, Donjaba, Ogima Kwe, Ganund Majig Gakina, Gui Webama Debwewen. Thank you. It's a pleasure to be here. I just greeted the first teacher and said it's a wonderful day. My name's Krista, as Kim has introduced me. My Anishinaabe name is Wind Changing Woman. I am the Otter Clan from Georgina Island First Nation, which is in Ontario on Lake Simcoe. And I am the legal director, which we can't actually directly translate. So I explained I'm like the little chief of the Ganundmajig, the advocates for Gakina Gui Wabama Debwewen, all those that seek the truth, which is the Anishinaabe name of Aboriginal Legal Services. And I'm thankful to be here. Miigwech.
Miigwech, Krista. And next I'm going to introduce Hannah Ashgray. Hannah is the executive director of the Sierra Club in British Columbia. She practiced public interest environmental law and worked as a researcher on Anishinaabe and Coast Salish legal orders for the Indigenous Law Research Unit at the University of Victoria. Welcome, Hannah.
Thank you so much, Kimberly. It's a huge honor to be here today and to be part of this conversation. I'm really grateful for the welcome from Dr. Dick, and I am currently living on Musqueam Squamish in Tsleil-Waututh territory, and my ancestors come from England on my father's side and from Scotland on my mother's side. Thank you.
Thank you, Hannah. And finally, we have Scott Robertson. Scott is a member of Six Nations of the Grand River and associate in the law firm of Nawagabo Corbiere, where he's practicing exclusively in matters relating to Indigenous people. Scott is certified by the Law Society of Upper Canada as a specialist in Indigenous legal issues, litigation, and advocacy. And as most of us know, Scott was also the president of the Indigenous Bar Association from 2017 to 2019. Welcome, Scott.
Thank you very much. Thank you, Kim. Thank you very much, Dr. Napoleon and the University of Victoria for the kind invitation. I'm humbled to be on this panel with some wonderfully powerful Indigenous advocates. And so you always question yourself when you're on a panel like this as to why did they invite me, but hopefully I can provide some context. But I also want to thank the University of Victoria very much for creating a safe place for us to have these conversations. I think it's important to recognize that it wasn't such a safe place for much of our history here in our treaty relationship with Canada. So we should not take that for granted. And so thank you for creating that space.
Thank you, Scott, and thank you to everyone for joining us today. And so the first part of our conversation today, as Val mentioned, is to focus on complexities in the current legal landscape. And we're going to ask each of the panelists to share their experiences in the field and elaborate on the difficulties that they have in the existing legal system. So I thought to start off the conversation, I might offer a couple of my own insights from working at the Indigenous Justice Division at the Ministry of the Attorney General in Ontario. Through our office, we have been supporting First Nations communities in Ontario with the important work of revitalizing and implementing Indigenous laws. And just to get people thinking in the audience and also to trigger some of the panelists, there's two overriding main issues that I'm seeing currently right now in Ontario. And one of them is, I like to sort of call it the romantic Indigenous people dilemma that we have. And we are seeing that a lot of judges and crowns on cases are always willing and more open to introducing eagle feathers in the courtroom, having ceremonies outside on the lawns of the courthouses, having sacred fires and teepees. And to them, that's often as far as they will go when they think about Indigenous law. And so how do we push the systems and the institutions where law is happening to go beyond sort of that romantic notion of what Indigenous law is? And then secondly, the other thing that I'm seeing in my role currently is this higher standard that's being applied to Indigenous law and to First Nations and Indigenous governments in implementing their laws, in that we're seeing police and crowns not wanting to implement the law, apply the law, challenging the law, putting extra scrutiny to the law, that we don't see of other governments. The authority and the constitutionality, the charter, all these are being raised, and somehow everybody's the authority on deciding whether the law is valid or not, as opposed to letting it go to the proper institution or the decision maker that should be making that decision. So I'm just going to throw those out there, and we're seeing a lot of these challenges during COVID times around COVID laws that have been made in communities. So what I'd like to do is ask each of the panelists, and maybe I'll go in the order of how we introduced you, to hear from each of you about some of the opportunities and challenges that you are seeing in your jurisdiction, in your communities around implementing Indigenous law. And if I may go to Chief George Wilson first.
Thank you. ACME Siaya, I Tunishquilawin, E quick snalats, at the Sitia Ama, the Mena Sialia, the Mena Queth Synthalia Isla Hotiam, the Amath, Quethan Sakalo Isla Hotiam. Haitsepka. Greetings to our honored guests and my dear ones. I have good feelings in my heart to see all of you today. In our language called Kamitnam, I said my name, Sitsiaama, Sialia, and I told you who my parents are and who my grandparents are, because those pieces of information are important because it lets you know that I know exactly who I am. I would like to thank our good family friend, Dr. Skip Dick, for his welcome to Lekwungen territory. Happy to join all of you today. I just want to note that we started with the music you heard in the beginning is the Quesadillas Anthem, or in my community, we call it the prayer song. That song was gifted by our late leader, former Chief Leonard George, to the Quesadillas Nation. So it's an important song in my community. So I'd like to say, Hi Chikasiam, Hi Tsepka, thanking all of you for giving us that beautiful rendition, and our having Skip welcome us in such a beautiful way, and for us to thank him for his words. That's all part of our laws. It's all part of who we are as Mohawk people in our communities. We have to do these things. You asked 4 really interesting questions, and I'm a little bit nervous about the people that are on the panel with me, that I am on with, wondering, just like Scott said, well, here's hoping I can contribute something of. When we look at the challenges to contemporary Indigenous legal practice for our own people to begin to use our own legal orders, we're faced with challenges that colonization has put upon us. We can't have our own law without our own languages. And in my community, we don't have a plethora of speakers in my community, all due to the colonization that occurred. And our legal orders, while we might know them, the mainstream does not. So we worry about, well, how would it be used? We went to it's no secret, my community opposes Trans Mountain Expansion Pipeline. And we went and presented our own law to the NEB to say why it shouldn't happen. And our community was worried about, well, what are they going to do with our law? Our elders said, and how are they going to interpret it if they don't know who we are? Do they want to know who we are? So we told them that we're going to bring our law, our language, our culture. We're going to do things in our way, and we're going to put their law right beside our law. And we aren't going to make our law fit into theirs. And we're not going to make their law fit into ours. We're going to put it beside it. And well, that's what we did. And we see and we see what happened there. So that's another challenge. We need to ensure that our communities don't feel like we aren't being heard in the courts in the way that we want to be heard. But we need to find a way to ensure that our communities don't quit, that our communities don't say, well, we've done it once and it didn't work. Why should we keep trying? Well, I think we have to keep trying. So that also goes to how to stop or prevent laws of oppression. It's bringing back our own and making sure that our own people understand our roles and responsibility in protecting our land, our water, and our people. One of the things that Saulteau has done in protecting and upholding our responsibilities to the land and the water as given to us by the Creator has been to create a stewardship policy. So that's using things that they understand to ensure that our laws are being put forward, to ensure that our laws in terms of referrals are being used when we consider projects that we would agree with on our territory. And to do that kind of work is it's really important to be looking to the knowledge keepers in your community. They might not always be the elders, but elders is the first place that we go. You need to include people. You need to make sure that people are feeling heard. Because in our communities, I'm sure this is the same across Canada, sometimes there are segments of our communities that don't feel heard. They all need to be heard when we do this kind of work, because we all need to be part of the upholding of the laws. And that helps us in making sure that whatever that we bring forward, the colonization that has happened to us, all that baggage that we carry around doesn't come into who we are and how we bring out how our law is. We need to think like our old people think. We need to be able to, there's a reason why our people do ceremony. When we do ceremony, we're our purest selves, and we have the ability to hear. We have the ability to see. I know that in mainstream, they don't really put too much stock in dreams, but dreams are the way that things come from the other side to us. Like, we really, really believe in the dreams, and we believe in being able to bring those ideas forward to our communities. And I'm pretty sure that's 10 minutes. I hope it is. I'm just going to stop there. Thank you, Kimberly.
Thank you, Chief George Wilson. I have lots of comments to make, but I'll save them for the next round, and I'll turn to Krista next. Krista.
Miigwech, Kim. I just also wanted to say miigwech thank you to Dr. Skip Dick and to Chief George Wilson. It's interesting because I also think one of the most important things or barriers that we have to overcome in order to ensure or overcome those challenges is to meet people where they're at. Because of the colonization, because of the colonial practices, we can't assume that we can always just sort of sit in that original place of knowledge. I also agree with Kim. I see a lot of within Canadian justice systems. I feel like it's a lot of placating, and that there is some genuine uptank of like wanting to learn more, but it's always at a level that is sort of more out of interest rather than genuine practice. So, the inclusion of eagle feathers, yes, they're important. Allowing ceremony, yes, it's important. But the other side of this I see is our people have been great lawbreakers for a long time. Like when you look at something like the Indian Act or the bans on our spirituality and the bans on us being able to do cultural practices, some of those practices still exist because our people continue to practice them despite that law that was imposed. And so I like the way you talked about putting the laws beside each other, but you see what happens. One always trumps the other. But in another way, there's a quiet resistance, right? And so this past weekend, on a very personal note, my mother passed away a year ago, and in our culture, we do ceremony that's really important. And then this year we do a sacred fire. And at that sacred fire, we had Medawin Lodge elders singing traditional death songs from like way before contact. So there is something to be said about the resilience. And what it reminds me is that law is not frozen for any civilization or citizenship, right? Law is always a progressing thing, but sometimes ideologies, they become stagnant. And when we look at Indigenous cultures, often colonial practices have really influenced the way we believe tradition should be. And it's hard to sometimes segregate or separate those things. Undoubtedly, we're impacted by intergenerational harm. But for a number of us, we rebuild, we rejuvenate, we create new laws within our First Nation communities or other Indigenous communities. And as our laws are evolving, we need to embrace and practice intergenerational strength, right? We need to recognize there is a need to move forward. So I know there was 4 questions asked of the panelists, and I'm not going to spend a lot more time, but I did want to say, one of the good questions was, what does it mean to stop or prevent laws of oppressions from moving forward? there has been a little progress, but let's keep them separate for a minute in Canadian law. So, I mean, we can look at big cases and we can say, oh, look, Marshall said we could do that. Oh, Delgamuukw said this. More recently, in Ontario, there was a case called Our Turtle, and the justice that made the decision, it's not a perfect case, but I do think it's progress. Basically recognizes the circumstance of the people where this particular case takes place impacted their traditional lifestyles and disrupted it so bad, causing systemic separation of children from their parents because of things like the residential school, upsetting delicate family structures. And I would point to that case to those who might be interested, paragraphs 99 and 100, where the judge basically explains that it's the Canadian laws that have contributed to undoubtedly exacerbating existing problems in vulnerable and disabled First Nation community, and that it's not just as simple as over-incarceration, but rather it's a direct extension of the coercive effects of colonialism. So I see this case as progress, but I see it as Canadian law. And when we talk about how do we revitalize and bring our laws back in, I think what it means is we have to empower our own communities and people to be part of law creation, that we need to hear them and know where they're at and work collectively together to put into place the things that we need. If we try to sort of bowl through, like as a Canadian lawyer, if I think of trying to create law and doing it in that very methodical Canadian or Eurocentric way, I'm missing the bigger picture. I'm missing the opportunity to learn, to grow, to pull in that inherent strength I have just by my blood memory or the virtue of being an Indigenous person with a greater awareness and knowledge. So I don't think we can ensure colonization isn't propagated in all the work we do, but I think, Scott Robertson had made a nice comment to UVic about the safe space. I think our work includes continuing to create the safe space, meeting people where they're at, and remembering that law is an evolving thing. When times change, some of our practice have to change, so long as they're grounded in those teachings. We have to recognize the diversity even amongst ourselves now and what we've become, having been so resilient through all of the colonial harm. Chimigwech.
Miigwech, Krista, if I can invite Hannah now to share a few words.
Thank you. Yeah, I really appreciate Chief Leah and Krista's words. And I too was wondering all weekend why I had been invited to speak. And it's just such an honor. I'm so grateful to Dr. Napoleon and Dr. Murray for this invitation and for the chance to be part of this really important conversation. So my role right now is as the executive director of a not-for-profit environmental organization, Sierra Club BC, that has a long and complex history of harm against Indigenous communities and undermining Indigenous law and governance. So Sierra Club has been around for 150 years in the United States and for over 50 years in British Columbia. And most significantly, we have, as an organization, a history of advocating for the creation of parks without the consent of Indigenous nations on whose territories the lands and waters are situated. And we've also participated in the creation and perpetuation of narratives that erase thousands of years of Indigenous governance and application of Indigenous law over territories by describing land as empty wilderness. So I've been working over the past couple of years with my colleagues who are both Indigenous and non-Indigenous at the staff and board level to try and grapple with this history and to begin to disentangle ourselves from this past and ongoing complicity with the colonial project. And I just wanted to take a minute here to acknowledge one colleague in particular who is on the leadership team with me, and her name is Charlene George. She is an intercultural educator with advanced degrees in education. She's a fluent Sinchothan speaker, and she's also a member of the Sauk First Nation, and she's leading a lot of the work that we're doing as an organization right now. So one of the first steps that we have taken over the last couple of years is to make a commitment that we no longer advocate for the creation of provincial or federal parks, except when that is being led by, or there's a call from an Indigenous nation on whose territory the land is located. And we do support calls for Indigenous protected and conserved areas when we are invited by a nation to offer support and when we have the capacity to do that. So about 1.5 years ago, we issued a statement of accountability called Balancing the Canoe, where we really tried to look backwards in our history and in our ongoing practices to understand better our relationship as an organization to Indigenous law and to understand the harm that we had done and we're continuing to do in the way that we operate, and to make a commitment to learn to do things differently moving forward. So I think one of the biggest tasks that before us right now as an organization is to resource ourselves over the coming years to be able to increase our capacity to recognize Indigenous law and to be able to respectfully engage with Indigenous governance systems and Indigenous law. So like a lot of Canadian charities and advocacy organizations, we have a lot of capacity that we've built over the years in how to advocate with the provincial and federal government around colonial law. But as an organization, we really lack a lot of the skills and knowledge about how to do that in a respectful and appropriate way with Indigenous governments and in a way that upholds and acknowledges Indigenous sovereignty, even or maybe especially in cases where we might be taking a different position than that nation in terms of the outcome that we're hoping for based on our role as an environmental advocacy organization. And I think people here have talked a little bit about the romanticization that happens of Indigenous peoples and settler communities, and certainly within the white dominant environmental movement, that has been a huge, huge issue. And it's one that our organization has also contributed to in the past. And that's also something that we're really trying to change about ourselves, is to stop that romanticization that can happen of Indigenous peoples as natural land defenders or land protectors, and instead to respect the full complexity of the different priorities that Indigenous nations are balancing as they make decisions about what is best for their lands and their territories and their peoples. So that's the path. We have a lot of work to do as an organization, and we are really looking to the work that all of you are doing, and to the work that the Indigenous Law Research Unit is doing, which has been a huge support and source of learning for us in different ways to be able to change the way that we operate and to develop our capacity as an organization to respectfully engage with Indigenous law and governance. So I'll stop there.
Thank you, Hannah. Thank you so much. Scott, if I can turn to you for the next 10 minutes.
Sure. Thank you very much. It's always difficult being at the back of the canoe when you have 3 powerful rowers in front of you who have certainly provided great context, but I will add just a little bit. This particular topic that I'm going to bring up always makes me really popular, especially when you're in a room full of lawyers who have worked very hard to obtain their status and become lawyers and whatnot. And I often begin my conversation with, as lawyers, we are agents of harm who have done incredibly bad things to Indigenous people from all corners of Canada. And you say that and people are very offended by that and shocked and say, well, I don't carry those things out in my practice. But we have historically been silent as organizations, as bars, associations from across Canada. We've allowed laws to be passed and enforced against Indigenous people. And sometimes we as lawyers have actually committed that harm ourselves in terms of presenting those arguments. And we continue to do so today. Those arguments are being made as we speak in courthouses across Canada and provinces. And so we have an obligation to educate ourselves, to educate the judiciary, to educate law schools about what that harm means and what forms does that harm come in, because some people don't even realize they are committing a harm. And when Chief George Wilson speaks about her community bringing forth its laws to the National Energy Board, I mean, think about the imbalance of what that must look like. You have a legislated board of people who are basically promoted to deal with pipelines and the running and operation of pipelines. And in that space, we're talking about creating safe spaces. They're tasked with interpreting an Indigenous law, and a law that encompass all the perspectives and all the traditions and all the history and culture of those people. How is that ever going to happen? So when we set up our initial calls for this panel, we talked about, and one of the issues that came up was institutions matter, right? Like it matters where you present these laws and where these laws intersect. And we, as a colonial system, have created structures which don't have any space. They were never intended to deal with or interpret Indigenous laws. Why would they? Because Indigenous laws have been suppressed, and as Krista has indicated, we had to go into the back rooms and into the forest to be able to protect and to practice our own cultures. And longhouses were raided by police, and like the history in Canada is replete with basically trying not to just suppress, but defeat and eliminate our cultures and our laws. But here we are in 2021. We'd like to think that we're a bit more of an enlightened society. We talk about reconciliation, right? And so the question that you asked in terms of the challenges to contemporary Indigenous legal practice, well, it's when people say, I'm going to go to law school and I'm going to help Indigenous people, like, is there a greater challenge than that? By going to law school, you essentially spend 3 years, and not your law school, Val. That's your law school is not included in this basket clause. But you go to most law schools in Canada, and you're trained for 3 years in the colonial system, right? You take trusts and laws, and you take property law, but it's all based on a colonial structure, right? None of it ever deals with Indigenous perspectives or how to engage each other. So it really is kind of engaging in Indigenous contemporary issues. You have to forget what you've just learned. You have to forget in terms of those perspectives. And you really are basically a translator. Like I tell people all the time, I'm not really a lawyer. I translate. I try to translate colonial laws into Indigenous perspectives, and I try to translate Indigenous perspectives into colonial laws. And so I feel somewhat disingenuous, right? I don't get to practice Indigenous law like we talk about. But I'm just, the contemporary version of what we do is on the ground, and you see rights being violated. You see people trying to assert rights, those are Indigenous clients, and you try to find this happy medium, which shouldn't be foreign to either party, right? We think about, the covenant chain from the perspective of the Haudenosaunee people, of which I am one, right? And so this relationship was basically based on respect and renewal, right? Like, let's not forget where we came from. When the Europeans showed up, we brought them in, we accepted them as brothers. And we seem to have forgotten that original relationship of respect and renewal. So that's what we should be doing right now in terms of perspectives. And many good people are definitely looking at this. I mean, Krista has brought up that there is this kind of tokenism of at least putting on a face of addressing Indigenous perspectives. That's a step. It opens the door. It's certainly not where we want to be. And courts, the federal court, I'll throw a shout out to the committee that I sit on. We're definitely looking very clearly at the rules and procedures and practices of the federal court, and they're very earnest. I say the judges that are involved in that committee are earnest in the sense of, how do we make changes? What are we allowed to do in the box of the rules that we've been given? So I applaud those efforts. I applaud the efforts of the hardworking Indigenous lawyers who are in the communities. I applaud the efforts of Hannah and her organization of addressing some of that colonial past and recognizing that we haven't done things properly, but we're willing to listen and we want to make a difference and we want to bring in those perspectives. So we're going to have to use those organizations like engineering practices, like the firms that Hannah's associated with. We're going to have to rely on them as allies, because we can't ourselves. There's not enough lawyers, first of all, to be able to spread that message. So I think that is a challenge, and a challenge that we all have to tackle.
Now, Scott, for that. Thank you. So if I may, when I listened to all four of you speaking and your perspectives and some of the complexities and challenges that you identified, one of the things that I think was common in all of your presentations was this this idea of roles and responsibilities. And knowing and learning roles and responsibilities, whether that's as Chief George Wilson talked about, the community's roles and responsibilities in learning the law, teaching the law, passing the law on, to Hannah speaking about the roles and responsibilities of an institution, an agency that wants to change how they've been working with Indigenous people. And, from Krista's perspective, the roles and responsibilities of making sure that laws aren't frozen in time, and how do we evolve with the work of Indigenous organizations and legal organizations. And then finally, Scott talking about these big institutions and lawyers, and what are the roles and responsibilities of the courts and judges and lawyers. So I'm going to pose this big question, and hopefully one of you or two of you might put your hand up and answer it. How do we teach about these roles and responsibilities? When we think about, for example, just to take lawyers and judges, we have legislation that tells them what their roles and responsibilities are. We have codes of conduct for lawyers that tell you what your roles and responsibilities are to the Law Society and to clients. And within community, I hear from different communities that, for example, some Haudenosaunee communities, they say, we know what the Haudenosaunee laws are. We just need to make sure that the community members all know that. And so how do we pass that on to the communities and make sure that everyone, especially when you have large, massive communities like Six Nations, how do you make sure the community knows what their laws are? So I'll just leave that and see if one of my good friends wants to take a stab at answering that. Krista, was that your hand up? Go.
And it's a big question, and really we don't have time today to get as deep as we want. But again, I think of this past weekend where we were involved in Kanehsatake, part of our laws that is part of a sacred path, right? And one of my uncles, who's well up into his 80s, had explained to the circle, we didn't always have these traditions in our community, and we didn't get to participate in them. But then the next generation, as they're going out, talked about how we've been sharing knowledge despite not necessarily having the full ceremony. So, I had an aunt who taught us all the medicines that are traditional to our territory and what they do and how you prepare them and when you collect them and when you leave them be. And that knowledge itself is part of that Naknagawan, that law that helps us carry information. And so the knowledge spread. So a lot, and this is my one point about tapping back into that strength we have. It's almost like we already have the knowledge structures. We just don't look at them in that sort of colonial lens or Canadian legal way to understand we already have a lot of the knowledge and information. And now it's about how we bring it together. And so communities, we see this in different ways, right? We see it in Canadian law through things like the Indian Act, or we see, communities that try to do the side by side, and it doesn't work well per se, because there's always this trumping. And so how we get other people on board, I think in some parts, because let's be honest, training is helpful. And there are those that are generally want to take up the knowledge and want to practice it. But the legislation, the rules, think of something like judicial independence. A judge has the ability to have judicial independence. So do our elders and our lawmakers. We just don't call it judicial independence. So I think part of it is we're on this path to rediscovery of the knowledge and the power we have. And I would love to say we're there, but we're not, right? Like I am working on learning my particular dialect of Anishinaabe, which is an island that is different than some of the other ones. And it's been years. I've literally been spending years, and I'm not fluent, and I never say that I'm fully fluent in my language. And so, where we are at the next stage, looking forward to our kids and encouraging their development in the sharing of that knowledge, I think is key. And we share that knowledge with our allies, and we bring our allies into that same canoe or that same space to remind them that they also have responsibilities and obligations, because when everybody shares this knowledge, we actually have more power collectively. we actually are more enriched collectively. I know that doesn't answer everything you ask him, but I think that's my perspective. Thank you.
Thank you, Krista. That is exactly what we are looking to start thinking about and how to do that. And I see that Chief George Wilson has her hand up.
Thank you, Kim. Thank you, Krista. I really agree with everything that you said. It's going to be through the bringing forward of our oral history, as well as the revitalization of our languages. And sometimes, as Krista mentioned, that can be difficult because there are few speakers, or perhaps like in my own language, in our particular language, there aren't any mother tongue speakers left, but we have similarities with neighbors. So we borrow curriculum from them. It's through those mechanisms that we're going to be able to bring things back, and actually helping our communities to think about what we know. I started out interviewing our elders for a specific claim piece of work that we were doing way back before I even thought I wanted to be a lawyer. And I remember sitting with an auntie who was like 70, and she said, you know, Leah, I think I don't know anything. And I told her, oh, auntie, you know more than you think you know. And she said, do you think so? And when we started talking to her about what she learned how to do on the land with her grandmother, she realized, oh, wow, I do know something. I know more than I thought I knew. Well, we all have elders in our community who are feeling like that. You know, I don't have any education like you have, but really they have more education than I have. They have PhDs in being Tsleil-Waututh, and I'd trade every degree I have to have something like that. And I think that's really important, helping the people to understand that there are the laws that they're following right now in terms of, well, I live in the city, so it's not a lot of harvesting going on, but we do harvest crabs in our community. We're down by the water, and there are rules and laws around what we do. And the young people who are doing it now don't actually know that they're following laws. We need to be able to reach out and help them understand. And we're doing this in part with our new school on reserve. We started a school because of COVID, and our people didn't want to send their children into public school. So we started one that focuses on education on the land. So we're teaching children about what we do on the land and how we protect the land and what our role and responsibility there is. And that's where we start. Thank you.
Thank you. I'm going to invite Hannah and Scott if they'd like to jump into this conversation.
I don't have anything to add. I really appreciate what's been said.
Well, I can just piggybacking off of Chief Maria Wilson and Krista. I mean, you how do you teach the law? You teach it by practicing. And I think we don't give ourselves enough credit. When I say us, Indigenous people, and of course, I know that's not a pan-Indian kind of approach. I know there are so many different laws, and obviously the way different Indigenous communities practice them. And so there is this kind of upswell of, well, how would we be able to deal with all of these laws? And I think that's just, that is a colonial imposition, right? In what world can you possibly bring all of these people together and think that there's one law that everybody can subscribe to? I mean, it's impossible. So I think we do need to kind of look at law from the perspective of the people laws have to mean something to the people that practice it. And so we have to look at, well, if these laws have been oppressed for so long, it's going to take some while to revitalize them, because I don't think they're gone. I don't think they're just lying under the surface, as just John Burroughs would say. They're just awaiting to be awakened. And so that lies on us in terms of the leadership within the communities. Again, I hate to be the broken record, but it does come back to creating a safe space. And as long as people feel that their laws are valid, that they mean something, that they can be enforced, as Kim talked about, one of the biggest problems right now across Canada is that First Nations are taking the initiative, right? They're and not just First Nations, but Métis and Inuit communities as well, and they're enacting their own laws, and they're taking those tough steps to self-determination and self-governance. But then there's this, what happens when that law needs to be enforced? And the enforcement provisions become problematic. So you have laws that can't be enforced. You have enforcement agencies that won't enforce them. And so you're kind of in this vacuum, right? There's this kind of gap between administration and enforcement. So that's going to have to be resolved somehow. But I still encourage our clients, I encourage my own community to forge on and create laws and educate, obviously, by practicing. But if you think about it, we're hard on ourselves, because if you polled an average Canadian off the street, they don't know a lot about our own, you say the colonial laws, they don't know a lot about the Fish and Wildlife Act, or the Boating Act in Ontario. Like, they just don't know a lot about those. They know there's a body of law out there, but they really don't know what it is. So we shouldn't be so hard in terms of, how we have such a handle on our own laws. But I think practicing is probably the best way.
So I'm mindful of the time, and I know, Val, you want me to wrap this first half up so we can go to a break. I'm just going to close by saying this part of the panel by saying I'm really reflecting back on the Truth and Reconciliation Commission reconciliation volume, and how there's a chapter on language and there's a chapter on law. And I've often thought about how we should have did a better job linking the two together around language and law. And the importance of both being revitalized side by side, as Chief George Wilson and others on the panel have said. So I believe we're going to have a short health break. Val, how long do people have? 5 minutes. And then we'll be back for the second portion of the discussion, and we'll open it up to the Q&A after that. So we will see everybody at 4:28, if I give you a true 5 minutes. That's Eastern Standard Time.
Ho, 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 eh, la, hey, ah, hey, ah, hey.
Ho, he, lo.
Welcome back, everyone. So I'm feeling enriched by this conversation that we've just had, not only just because of the kinds of experiences that our panelists and as well as the co-facilitator have shared, but because there's so much courage in many of their words and the kinds of issues and questions that they shared that they're grappling with. You know, in preparing for this panel, Kim Murray and I were talking a little bit about the words of the amazing elder Stephen Augustine. And one of the things that he said was when colonialism and the experience of colonialism can be likened to our canoe being tipped over as Indigenous peoples, that our canoe has tipped right over and everything has fallen out of the canoe. Well, we've got that canoe back and we're putting things back into the canoe, but it's not the same. It's different. It's different because of the experiences we've had since, because of all the other kinds of changes that have gone on in the world. And it's just such a smart analogy that he shared to get us to think about what have the changes been? What do we need to account for in our histories? And it's so important that we keep reminding ourselves of that, because sometimes I hear Indigenous peoples as well as non-Indigenous peoples talking about us as if we've been the same for 10,000 years. Now, we know that this is not the case. And there have been changes, and the job of every generation has had to solve the problems before it by drawing on those legal resources of the past. And every generation has had different legal problems to solve. So we are in a new era. We're building that era. And some of that work is about rebuilding Indigenous law as well, to recover that canoe and to match to respond to today's issues. I often get asked by people, jurists and many others, people ask me, what is Indigenous law? And I've started to just say, it's law. That's what it is. And then we can have the conversation from there as Indigenous law being a source of principled reasoning, a source of principled reasoning for problem solving. And we can see some of the lower courts now drawing on Indigenous law in that way to assist in the thinking through and understanding of legal problems. So there's obviously much more work to do, and that's what we're going to take up now in the questions that I'm going to pose. Before turning it over to the panelists, there's been mention of UVic and the work we're doing here, and I'm really proud to be the director of the Indigenous Law degree program that we have here. And this September, the 4th cohort of students are coming in to join us. And next year, our first cohort is going to be graduating. Can you imagine that this is it? This is happening. So, you know, all of the rebuilding and expanding of the Canadian imagination that is necessary to make real change happening is the work that all of you are doing, as well as all of our students. The future is going to change when we reimagine it. And that includes being able to think across legal orders, just the same as we have to think across languages with concepts, with the ability to learn and teach by analogy and metaphor, as our ancestors have always done. We wouldn't have the oral histories that we have now if our ancestors hadn't been able to do that, if that hadn't been a part of their jobs to teach the next generation. So I am, you know, there's, again, lots more work to do, but it's multi-juridical Canada, and we're all legal actors. We're all legal actors, and wherever we are in the relations of power that surround us and surround our communities, we're there and we're making a difference. So this session was to shift the focus a little bit to get us to think about that future and our role in that future. So how do we realize this future? How do we continue to realize this future of Indigenous law, of Indigenous legal practices, these processes of managing all aspects of our societies, and you know, that are as important today for every aspect of our lives today as they were in the past. So here's you know, some of the questions. How do we, and some you've already started to get into, like how do we reestablish, rebuild our legal orders so that they operate alongside and in collaboration with other legal orders? Now, we often think of Canada, just Canada, but we are multi-juridical in that we have Indigenous internationalism across this land too. We have intersocietal laws that have governed our relationships between our societies, and that work still has to go on. So in this new space of legal practice, which is much bigger than the kinds of things that you've mentioned courts doing insofar as, you know, eagle feathers and so on, you know, I'm sure done with the best intent, but it's just too limiting. The imagination is too small, and we have to blow it open with much more possibilities so that people can see Indigenous law. And that's the thing, like so much of our Indigenous laws and our legal practices and our institutions have been rendered invisible, and they're still being rendered invisible. And so our work is to undo that aspect of colonialism. So I invite you to share your perspectives about how we can move forward, and how we deal with things like when there's a resistance to having Indigenous laws being interpreted or being enforced by what's seen as a foreign body with Canada, when there's tensions between the legal orders. And how do we break down those barriers that exist still, is part of the state, is part of Canada, that get in the way of the kind of coexistence that's necessary if Canada is truly to be multi-juridical. Right now, if the wisdom and the strength and the legal resources from our societies aren't part of the conversation, that is a failure on the part of Canada to harness these resources to create this new future, to create this new era. So I will start with a different direction in calling on our panelists, and I'll begin with Scott. Scott, talk to us about your ideas here.
Thank you very much, Val. Great introduction, by the way. just being here, I feel enriched, which is always, it's always nice to step away from your practice, even for 5 minutes, just to have some grounding. So I think what I always do is, I thank Kimberly for her hard work. I call upon often in my practice the principles that were set out in the Truth and Reconciliation Commission, and specifically number 8. And I think one of the principles is talks about supporting Aboriginal, I insert Indigenous peoples' cultural revitalization and integrating Indigenous knowledge systems, oral histories, laws, protocols, and connections to the land into the reconciliation process. And these are determined to be essential. So that word reconciliation gets thrown around a lot, right? And there, you can cover a lot of sins when people say, well, we're reconciling with Indigenous people. You know, what does that mean? So I think it's the entire suite, right? It's not just the laws that need to be what we call integrated. And I was just looking at some of the chat questions, and there was an interesting chat question about, you talk about parallel legal systems, and why isn't it that the Indigenous laws should be superior to colonial laws? And so there's an interesting conversation with just that. You could have an entire conference on that, but I do truly believe that the relationship is equal, in a sense of, we should be relying on each other's legal systems when we can, when it's beneficial, when it's convenient. Why wouldn't you, right? I mean, you've got this entire basket of Indigenous laws and teachings that are extremely helpful just on the surface of scratching some of what we know about Indigenous laws, where you could see resolution and disputes being put over into, circles and those kinds of things that would just make a lot more sense than this adversarial judicial system that we're currently stuck in. So I think there's a huge growth opportunity. But what I see the biggest part of what we're doing is basically disarming the fear in both of these legal systems, right? What is the fear? What are you afraid of? Why won't you take that step? And so I think that's part of again, it goes back to the translation services, right? Like you have to kind of translate what those laws mean and how they can be incorporated. But if you look at a legal system in terms of what does it do, right? What is the law? What does the law do to a society? And I think that's kind of where you start your conversation, and value. You and John Burroughs have done a really good job of breaking down those structures as to what is a law. And I think that's important, right? To the essence of how we regulate ourselves, how we govern ourselves. So that, I think that's important in terms of how do we mesh. So again, creating the language where judges within the current judicial system in Canada can feel comfortable saying, well, what is this Aboriginal law or Indigenous law that I'm looking at? How do I incorporate it? How do I be respectful of it? Does the community actually want the law asserted in this forum, in this institution, right? So there's a whole bunch of stuff that has to happen before you even get to that discussion. And I think that sometimes doesn't happen within that conversation as to the two parties actually sitting down and saying, okay, how do we, first of all, we have an issue. How do we resolve the issue? So whether that be treaty interpretation or a title claim or a criminal proceeding, there should be this discussion of what is the best forum in which we can, is this going to be decided in the community? Is it going to be decided in a courtroom? Does it get decided by a judge, by a circle of elders, maybe a hybrid of the two? Like those are kind of conversations that would be important. And as lawyers, I think we're obligated to do that because we are always obliged to try to find the most, least expensive, the most expedient, and the most judicial kind of, resolution of our client's claim. So we're kind of obligated to do that. And if you can draw upon Indigenous teachings, that would make it cheaper and easier and feel more like justice, right? Because I think it's important to know that justice isn't just to be done, it's to seen to be done, right? And that's an important aspect of justice, that people feel like they've been heard, that whatever their issue was, that it was fully vetted and resolved, and people feel like they've been part of the justice system, not that the justice system has been thrown on them. So I think that's kind of the struggle. But there are places, I mean, we talk about mediation in court proceedings all the time, where you have that opportunity to sit down in an early kind of phase of the whatever proceeding you're in and talk about, okay, here's what we're going to assert, and these are the laws that we're going to use, and get that out before you get into the decision making process, I think would be important.
Thank you so much. All right, Hannah.
Thanks, Val. I really love what you just said, Scott. I would not have been able to say it in such an eloquent way like that, but that really, really resonates with me. Characterized those relationships. When Chief George Wilson was speaking earlier,
Hannah, your voice, it sort of fades out a little bit. So if you can maintain being really close.
Sorry, I'll just put my face really close to the screen.
Okay, good.
Try that. When Chief George Wilson was speaking earlier about observing people in her community following the laws in the way that they harvest at the beach, it really reminded me of a teaching that was shared with me early on when I was a law student, really at the beginning of my journey, both learning about what Canadian law is, as well as about beginning to learn a bit about what Indigenous law is. And it was in 2012, I got hired on a project that Val led, and that Kimberly was also involved in setting up. And it was a project around revitalization of Indigenous laws, and a number of law students from across the country were hired to work on that project. And I was incredibly fortunate to be one of those students. And I got sent to Kanehsatake with Lindsay Burrows, who's also a lawyer and colleague, to Anishinaabe community on Georgian Bay. And I was sent to live with Lindsay and her family, with her grandparents and her aunt. And we worked with a team of elders over the summer to try and begin to document some aspects of Anishinaabe law around how Anishinaabe law addressed harms between community members and also between communities. And I was really just, as a settler person who had never been educated in Indigenous law, I was at the very beginning of my ability to learn to see and recognize Indigenous law. And there was an elder who really helped me named Carleen Elliott. She's passed away, but she gave me a teaching that really changed the trajectory of my legal career. And she gave me permission to share this teaching, and I'll share it now. She had been very concerned the summer that we were there about the health of the water on the reserve community. And so as an Anishinaabe woman, Anishinaabe Kwe, she had been really trained since childhood to care for the water. And so she had been in a sort of a lifelong relationship with the water of reciprocity. And, she would talk to the water, she would sing to the water, she would give offerings to the water, she would ask the water for protection. And she often spoke to Lindsay and I about that. And she also talked about her sadness, her concern that she saw a lot of other members in the community not nurturing that relationship with the water and not caring for the water or honoring obligations to the water as she understood it. And so one morning, Lindsay and I were sitting at the breakfast table with her Aunt Jenny, who had been to a band council meeting the night before, where there had been an announcement that a new bylaw was going to be enacted for the protection of the water, where there would be some kind of fine, so that if people harmed the water or put something into any of the streams or creeks that would be harmful to the water, that there would be a fine associated with that. And it was meant to protect the water. And so then Lindsay and I thought, oh, Carlene is going to be really happy to hear this. Let's go tell her. So we walked over to the Madoki Senior Center, where Carlene was living at the time, to share that news. And instead of responding in like seeming happy, she just kind of shook her head and she said to us, laws are for the lawless. And it took me the rest of the summer to understand what she had meant by that. But what I eventually came to understand was that the point that you had to write that law on a piece of paper and have an external punishment associated with not following it, that had so much less power than the kind of power that Carlene was living in her law, with the relationship that she had built since being a child with the water, that she continued to practice and continued to honor. And for me as a settler person, that was really the first time that I began to grasp the power in Indigenous law, and to see that compared to some of the environmental law I was learning in Canadian law, that was actually a lot less effective and a lot less powerful. And that really changed for me. That had a huge impact, because it really changed the way that I oriented myself in my own legal career. And I think this kind of goes back to what Scott was saying about, like, as a society, we're facing a lot of really serious challenges right now. And we really need to draw on the strongest wisdom and knowledge and law that is available to us to address those challenges. And the kind of continued failure of a lot of settler society to be open and to learn is we're really we're causing a lot of damage and loss to ourselves in not doing that. So I just wanted to share that. And I guess I don't want to take up much more time here, but I would say that in terms of at Sierra Club BC, one of the things that we're really grappling with is around kind of framing and language. We've talked about language today, and we really struggle with the kind of language and storytelling that we have around our relationships to plants and animals and to the lands and water. Like, English can be a very limiting language for describing some of those relationships, and particularly when we're trying to also engage with Indigenous law. So I mentioned my colleague Charlene George is leading a lot of our work in that area. And one of the pieces of work that I'm most proud of that we've done is kind of work around changing some of our storytelling around the climate crisis. And Charlene, who's also an artist, has led a project called Seeing Through Watchers' Eyes. And so her analysis, and coming from a Coast Salish perspective, is that the climate crisis is really rooted in a disruption of our relationships with the lands and waters, right? And a disruption that really began with the project of colonization and people being removed from their territories and those laws being disrupted. And so one of the things that we're trying to shift at Sierra Club is the way that we talk about climate, and the way that we kind of recenter some of that conversation around a need to re-enter into respectful relationships and rebuild those relationships with lands and waters, and in a way that is informed by and guided by the Indigenous laws of the people whose territories those are. So that's part of the work that we're engaged in right now.
Thank you, Hannah. Krista.
Yes, thank you, Val. Thanks, Scott and Hannah. Hannah, the point you're touching on, that lawlessness, is something I actually want to address too, and the concept of relationship, because almost anything I know about Ganaknagawan or Innagawan is always about relationship. And we as Indigenous people have these massive legal issues, not just Canadian legal issues, but issues like water. So thank you for sharing that story. Like as a Anishinaabe Kwe, I do have responsibility to water, which means I have to follow rules and laws about water. I was fortunate enough, and one of the highlights of my career was actually getting to work with Dr. Napoleon and Dr. Hadley Friedland. Basically, we had them come to the National Inquiry when we did a particular week that focused on Indigenous law and decolonizing perspectives. And getting to work with the two of them meant I had to read a lot of material beyond. I was watching the videos that came out of UVic. We were talking about how we were going to present it in a way that would sort of take up space and let people know. And interestingly, I learned a lot that week. That's not the interesting part. The interesting part was, I think, when you talk to any of the council out of that time that were in attendance at that particular hearing, a lot of us had little seeds that we came back to months later in different contexts when we were talking. But the issue we were talking about is one of these crises in Canadian society, which is missing and murdered Indigenous woman, girl, two-spirited, transgender, gender fluid people. And so Dr. Napoleon, this is something that stuck with me from like the point she said it in the testimony almost all the way through the process, because she's like, we need to start a part, and she said this earlier, Indigenous law is law. It's just that simple, right? And the work of Indigenous law includes rebuilding citizenries and rebuilding our lawfulness, because in all of this like colonial times, and I argue we're not in post-colonial times, during everything that we've gone through, we ourselves as communities have lawlessness. So we have to rebuild lawfulness. And the things that we need to think about, and you touched on this too, Hannah, is like defining and understanding the terms, right? We need to, as communities, put definitions around the things that we recognize are the harm or the problems, and not just fall to whatever might be in sort of the Canadian jurisprudence. We continue, even amongst our own communities themselves, to oppress and create conditions, is one of the things that Dr. Napoleon had shared with us. You can actually see the transcript and go to the National Inquiry webpage and pull up exhibits in the whole 9 yards if you really want to dig in more. But, Indigenous law, and this is, I'm just quoting Dr. Napoleon here, Indigenous law is a necessary part of being lawful together according to the terms of our own legal orders and those aspirations of safety and inclusion and fairness that both our legal systems are attempting to work towards. I actually took that from the testimony she gave, and I actually recreated it, and I had it as just like a little cutout on the top of my binders, because it's something that just jumped out at me. And as we look, and I'm going to use the example of the National Inquiry in terms of the questions that we were asked about, how do communities practice law? How can we ensure enforceability? I think we've got a long way to go on understanding how we can do that, but that what work can be done today. And I tap into sort of the National Inquiry and their findings and on their calls to justice. It flowed, after the Truth and Reconciliation Commission. The Truth and Reconciliation Commission had a lot of impact, and it had a lot of, but when you look at the actual principles for change, so the calls to justice, they're not recommendations, they're call to justice because they're based on a human right and Indigenous rights framework. And the first thing that the commissioners say in their findings is that, Indigenous women, girls, and two-spirited people, LGBTQ plus, are holders of inherent Indigenous rights, right? And so when they they set out principles for any of their calls, and one of them is a decolonizing approach, and that's found right within, and I'm not going to take the time to go through it, that's found right within the principles for change for the calls of justice. And one of the things that in terms of the findings, they make the findings that Canada has enacted domestic laws, including to but not limited to things like Section 35 and the Charter and human rights legislation to ensure the legal protection of human rights and Indigenous rights. But, there's a gap. Canada has failed to protect those rights. You can put it on a piece of paper, but if you're not going to actually enforce and instill it, then we have this ongoing breach of our human Indigenous rights. They also recognize self-determination and self-governance as fundamental Indigenous and human rights. And so I pull that all back because I think a lot of conversation gets lost in national inquiry because they made a finding of genocide or all these other really high level hyped up things. But at the base of it, the framework is human rights and in recognizing Indigenous rights. And they don't just call on the Canadian government, they call on all governments, including Indigenous governments and Indigenous representative organizations, to take urgent and special measures to ensure that Indigenous women, girls, and 2S LGBTQ plus people are represented in governments and that their political rights are represented and upheld. And so when Hadley and Val did that presentation, and they gave us a lived example of a community down in the States where a female band member was running for elections, but all the men in the community were trying to oppress that because the colonial practice has changed our perceptions. So when I said earlier, we got to make sure everyone's in the canoe, that we're going to meet people where we're at. That includes our children. That includes the women. That includes our two-spirited, transgender, gendered fluid. It has to include everyone. And it's hard. That's a hard order. How do you get all of those perspectives in a good way that's going to be meaningful? And I know we're short on time, and there's only one other point I want to make quickly in the short time we have is that also means not looking at the definitions of where Indigenous people are based on Canadian law. It's not looking at the provinces. It's not looking at the reserves that were created by the Indian Act. It's recognizing there's Inuit 5 regions, that there's Métis people throughout the country, that First Nation people, whether they're in communities, which sometimes might mean the law making around that is a little more regionalized, but also that there's Indigenous people all across the country and in major city centers. That's the work ALS does, and some of it's Indigenous-led processes, right? It's about having circles. It's about finding solutions with Indigenous perspective and Indigenous actors and allies so that the community can harmonize and reintegrate when there has been that harm. We have massive legal issues like missing and murdered Indigenous women, like unclean drinking water. We have a whole bunch of lawlessness, whether we impose it ourselves or we offend ourselves. So we need to recreate together so we can find that lawfulness and the definitions that make sense to us. I'm sorry, I'm so wordy, but I'm really passionate about this, and such big thanks, Dr. Napoleon. That I literally took that quotation and I put it on my binder to remind myself every time we got really into the thick of Canadian law, when we had to be real Canadian legal practitioners and finite little technical tools, and I looked at that and I reminded myself, we need to define lawfulness. Shimiwach.
Thank you so much, Krista. Leah, Chief George Wilson, how do we go forward?
Thank you, Dr. Val. Thank you for your words, Krista, Hannah, and Scott. I really appreciate them, and I really agree with everything that you all have said. And I really liked the lawlessness quote that you brought forward, Hannah. I appreciated that. And I like the way that Krista brought it forward to lawfulness and to what our communities can and are doing. Earlier, Kim had talked about the Haudenosaunee laws and courts. That is really something I would like to know more about. There are 34 laws, and you're able to enforce whatever the decision is. I think that's what we all need to be doing. Here we aren't doing that, but what has occurred in the provincial court are First Nations courts and circle sentencing. I've watched that just because I didn't know what it was. I thought I'd go and check it out, and it was really emotional. Watching elders, they had a panel of elders who actually spoke to both sides. It was really interesting to me because both sides were being heard, and the elders were giving counsel to both of the parties, and that seemed really useful to me. In my own community, when we started a constitutional building for our own community, one of the things that came out was the discussion around relationships and our relationships with each other. And at the time, one of our leaders said, well, this one nephew of his had committed this harm, and he wanted to come forward and talk to traditional council, which is in Saulteau. It's the council that's made up of the heads of the main families in our community. So he did, and he essentially got talked to by elders in our community to help him help show him, I don't want to say the error of his ways, but essentially that, to show him what he needed to do different and what he needed to do better. And people felt okay going away with that. So he made some restitution to whomever it was that he had wronged. I can't recall all the details, but it really showed the elders that this is the way that things used to be. People didn't get punished or shamed in the way that they do today. There could be a better way to do these kinds of things. In terms of considering barriers, I think, Dr. Val, you're doing that at UVic with bringing our own Indigenous legal traditions forward. And I really like the way that you said it in the beginning, that when you are asked the question, you say Indigenous laws are laws. The simplicity of that is something actually I'm going to be using as well, because they are. And that's really important, because mainstream, they don't really see it as laws. It all goes to that whole romanticizing of who we are and what our laws are. So I think that's the way to do it. And I go back to Truth and Reconciliation and the calls to action around education. Children in public schools need to know about who we are as human beings, with societies, with laws, with languages, with culture, with different cultures all across Canada. They don't know enough about us, and we see that. Well, I mean, we see that in the legal system currently. We have this one case going to BC Court of Appeal, Servatius versus Alberni School District, where a non-Indigenous person doesn't want to learn about other people's religions. They only want to know about their own religion, totally discounting the fact that our cultures are not our religions. It's who we are. It's our way of life. And because that case is making it as far as it is, that really says to me that our public school system is failing, that there needs to be a better way to make sure that people learn about who we are, the way that people learn about what happened to our communities, because we're not just about what happened to us. We aren't what happened to us. We're so much more. And that includes our language, that includes our law, that includes our culture, that includes everything about who we are. And that's what they need to know. And I think it's all coming back to education and our own education. UBC actually has First Nations languages being taught, and one of them is Hakkamaitam, which is our downriver Halkamalam. And when I took it too many years ago, there were non-Indigenous people in the class, and I thought that was pretty cool because it meant that someone else wanted to learn. Funny story, we have a fee-for-service daycare on our reserve, and so it means anybody can go there. And when my daughter was in grade 7, one of her schoolmates at public school said, "Kalila, my brother is one of your people." And she said, and she knew he's Juanitam, he's not Indigenous. And she said, "How do you figure that?" And he said, "Well, he goes to your daycare and he's learning your language and he's learning your songs and stories. so he must be one of your people. And I thought, that is pretty awesome, because that's how you know when you're one of our people, when you know your language, when you know your culture, when you know your history, your stories, and you know who you are. Thank you.
Thank you, each of you, for just adding so much to this panel and taking up the questions that you have. And there's our responsibilities to each other. There's our responsibilities, like as Krista has reminded me, to be lawful, to not be oppressive as we go forward, to be attentive to power dynamics, including gender and LGBTQ issues and all of those. And Leah for bringing us back to those little children. And it's when we're infants, that's when we learn about the laws in our world. And so part of the work that all of us have is, what are we teaching about our lawfulness, about our obligations to one another in our own families? And this has been terrific. And now we're going to turn to some questions, and Kim is going to lead that discussion.
Thank you, Val. And for everybody in the audience, please feel free, if you haven't already, to put your questions in the Q&A box, and we'll do our best to get to them all. And I'm going to apologize in advance if my dog starts barking. It's that time of day here where all the kids are outside. It's the end of the day. I just, before I ask the first question, because I think it's related, I just wanted to pick up on what all of you were speaking about on disarming the fear, and whether that's through education or choosing what is the best form to disarm that fear. And so we have a question that talks about, that asks, and it's from Vanessa from Victoria, where she asks, she says she's interested in this idea of presenting and applying Indigenous law side by side with Canadian laws. Can the panelists speak more to how they came to this idea as the appropriate interaction between laws, say, as opposed to Indigenous law trumping Canadian law, and how disputes may be resolved when those legal systems diverge? And so I was, when I read that question, I was thinking about this disarming the fear. And when earlier we talked about institutions matter, and how do we disarm the fear when often the fear is based on systemic racism? And so often the power is in the colonial system. And when we talk about diversions and mediation and where to go, it's often out of our hands and in the hands of the colonial system. And so this idea of the two laws side by side and the two systems. So if I'll just turn to the panelists and see who wants to take up an answer to the question. Indigenous law trumping Canadian law, or vice versa?
It's Leah. I'll take a crack at it. When we went to the National Energy Board, we just told them under our own law why we wouldn't approve the pipeline. And of course, the pipeline is still making its way. So we didn't stop anything, but that doesn't mean to us, that doesn't mean that we lost. To us, it just means, okay, now we need to find another way. So for us, putting our law next to theirs was telling them exactly how and why and where our law would stop the pipeline from occurring, because our obligation is not to oil. Our obligation is to the land and to the water, and there are too many unknown factors. Thank you.
Thank you, Chief George Wilson. Does anyone else want to add to that?
I'll take a crack if that's okay. I just didn't want to take someone else's time, but I guess, paramountcy of laws is the question. I don't think either law should be seen as paramount over the other. Again, my teachings from my people are about traveling down the river together in our own canoe, right? That's the two-row wampum that I was taught. And that is, that's the relationship that was agreed to way back when. And so, that idea, that symbolism of a canoe, which seems to be appropriate, you flow down the river together because that's the world you live in. So that makes sense. You're in your own canoe because you get to steer it and build it and maintain it. And as Krista pointed out very eloquently about who gets to go in the canoe and ensuring you've got everybody in the canoe, and that means all the people. So that's important, I think, to maintain that, that control over your own canoe. And I'm sure the original treaty partners, which were the Dutch, they had their own intention of keeping their canoes safe and secure as well. But the point of that is, when you're canoeing, is if one canoe is in trouble, you go over and you help them. Right. And I think that's very much implied in that relationship. So I really don't think it's healthy to get into this paramountcy of one law being greater than the other. Certainly not. You wouldn't want to speak from the language of diminished, like this law is lesser than ours. I don't think you'd want to get into that conversation. But I really do think that the laws should be considered not as whose law is more superior, but whose law we can draw upon. And I think that's really important. And I can see lots of people struggling. And I see people in the legal system. I see community members are struggling with, how do we interconnect? How do we develop our laws where they can be beneficial and helpful and not harm or hurt or impede our citizens? So I think the conversation needs to start at that level. And again, just getting us to level, right? Getting us Indigenous people to level would be a huge improvement from where we've come from over the last 200 years.
Thanks, Scott, for that. I'm going to move to another question because we have lots of questions and I know we're running short on time. So Lori asks, or it's more of a comment, and maybe I can ask Krista to maybe respond to this. As a lawyer, it's difficult to be asked to forget what we learned in law school. Rather, anyone who has gone to law school and have become lawyers must see themselves as conduits of change. We must use what we learned in law school in our practice and find ways to challenge the colonial laws that invariably work against Indigenous people. And I know all of you are doing that, and maybe because I know we have a lot of people watching, maybe some tips for junior lawyers that are or law students or people thinking about going into law about how they can do this.
So yeah, no, that's a great, thanks for the comment. It's a balance. It's not, every day is not easy when you're a Canadian lawyer or practitioner, but there are tips. And I do actually agree with you. Like, I feel like I can be, or my actions can help be conduit to change. And it requires, I'm not going to lie, it sometimes requires quite a bit of fierceness. I told this group when we were in our one conversation, I had in a courtroom once been told that my native jewelry, because I often wear big blingy stuff, was really pretty and decorated the court. And, I didn't lose my mind, but I did explain the only reason I was wearing that was so that the client that I represent, when he was on the stand, he had something to look at that he recognized, that was familiar to him and that had meaning. And the beadwork I was wearing was actually powwow regalia, and it had hearts, and it was a Anishinaabe, and it had our floral, part of our floral and part of our teachings. So I knew that I'd be able to have him look at me and recognize familiarity in a safe space by wearing that. And so there's tips. And so one of the things, people often ask, don't you get in trouble for wearing the big jewelry or doing stuff you're not supposed to? And I was like, I have yet to have any judge or coroner say, Miss Big Canoe, why are you wearing those large beaded earrings? And I don't think they would. And that's, this is, I think it's a little different when it's Indigenous people wearing things that have value and meaning to us. It's not just about the bling. It's not just about decorating the court. It's about recognizing symbolism that's important that might strengthen us. And so that's one of the things I do. That's a personal thing I do, is I find things that bring me strength so that when I'm there, One of the other quick stories I can tell, and it comes again from the National Inquiry, a lot of that was like publicly filmed. It was live all the time. You could watch, you can go to the website and you can watch and you can see me and you'll see me cry. It's the only time in courts I don't cry. In Canadian courts, I do not cry. You will see me in hearings actually with tears going, because in Anishinaabe belief, tears are healing, and it was a safe space to do that. The other thing was the very first time we were about to go live in a big family gathering, I got like a few moments jittered nerves in my stomach, and I was all worried about what I was going to look. Will they see my double chin? Am I wearing something okay? And it took a moment, and then I realized, and this is how I regrounded myself as a legal warrior. This is not my story. This is not my narrative. I'm helping be a translator, much like Scott. I'm helping these people share their truth. So my job doesn't matter. It doesn't matter what I look like or my nervousness. It matters that I have enough confidence to give these people the space to tell their story. And I feel like that almost every time I'm in an inquiry, inquest, anytime I'm in, different administrative tribunals or before courts. When I walk into even the highest level of court, I have to remind myself that I am not just representative of the Canadian laws I've learned, because I'm a Canadian legal practitioner, but that I am representative of my people. And if I don't come with some Indigenous perspective, whether people like to hear it or not, I just have to find the way to do it politely and honestly. And so for me, that's always been my biggest goal. And it's what, my parents and my grandparents and my family have always taught me, is that basic rule of respect. I have to respect myself in order to be able to give other people respect. And so you really, there's lots you can do. If you ever told me the work I'd be able to get to do in my legal career, when I first came out of law school, I would have been like, no. I was just happy I was going to be practicing Indigenous law because I was with an articling student with now Gabo Corbier. And I was like, everyone else was talking about what they got to do, and they're all working on Bay Street or here or there. And one day they were going to practice the area law they wanted to. And I got to start where I wanted to. And I've stayed in that lane. And I have been fortunate to be able to meet so many people. And like sometimes days can be a little defeating when you're dealing with such heavy stuff. But there's other days when you can be like, I had a little tiny part in help lifting that up. And so, if there's any encouragement, you go to Canadian law school, go to UVic because you'll get a better degree. But you go to Canadian law school and you feel a little defeated some days, but you do learn things. And you do learn ways to advocate for people. And you do, if you are accepting of knowledge and learning knowledge to use it to your best practice, then you're always going to be walking forward in a good way.
Thanks for that, Krista. There's a question I want to get to on climate change, but before we do, I'm going to call out Scott because Scott talked about the sacred grandfather teachings or grandmother teachings, depending what nation you come from, and implementing that into our law practice. And I think it's related to this question that Lori had. And I'm wondering, Scott, if you remember that conversation we had last week.
Yes,
and you
yes,
can
I
share
do.
a little bit about the love.
Sure. Yeah, no, and I actually know Lori. I had the pleasure. Lori was part of that class. I think they were registered at UVic, and they were from the north. They actually came down to Ottawa U when I was at law school, and they spent the semester with us, and we learned so much just about people from the north and in terms of their laws and perspectives. So I understand where that's coming from in terms of her question as to you don't just forget law school, absolutely, but you do have to try to forget in terms of what your principles are, right? Like you don't ever leave your principles at the courtroom door. And what we were talking about is the seven grandfathers teachings, which is an Anishinaabe teaching. And when, I've had those discussions with Crown lawyers, which, you get the blank stare across the room when you talk about, well, how do we incorporate these principles into the, looking for a settlement? And what principle would that be, Mr. Robertson? Well, love. Where is love in this decision? Where is love in how we're going to deal with this? And they just, that's a principle that nobody ever talks about. We certainly were taught love in the law school that I went to, but it is an important principle. So is respect, so is honor, courage. Those are the kinds of things when you're talking about principles in terms of making a decision that's going to impact somebody. And wouldn't it be wonderful if you took those seven teachings and you could base an entire decision on, okay, Your Honor, I have 7 points to make to you, right? And we're going to start with love. And that would be incredible. as opposed to, the legal tests that we're forced to, engage in. So I just think when I say forgetting what you've done in law school, I think obviously to practice law in Canada, you can't forget there is decorum, there are rules and procedures, but it's just not to stifle our own principles and our own teachings, and to feel comfortable doing that, right? And how do you feel comfortable? It's to make the person that you're working with not feel uncomfortable, right? So that's the extra burden of practicing law where you're incorporating Indigenous perspectives. It's our burden, right? We have to bring that with us. We have to basically teach everybody in the courtroom, because no one knows what you're talking about. And that's an obligation, which, when you sign up at law school, very much like Krista, I very much remember a conversation I had when I was in law school speaking to Patricia Montour, for those of you who had the pleasure of meeting Patricia before she was taken by the Creator much too early in her life. And I asked her that question. I said, what do we give up? She came to speak at Ottawa U. I was still in law school. What do we give up when we become lawyers and enter into the system? And Patricia just looked at me and said, it doesn't matter what you give up. You got to get in that room and we have to make a difference. So that was just the kind of way that Trish was. She just, there were no barriers for her. And so to me, that was the ultimate legal warrior, like just get in the room, because if you're outside, you're not making any difference. So you may have to swallow some principles. You may have to make some pretty hard choices in your life of how you're going to, represent clients when, the deck is stacked against them, but you take on that challenge, which is the extra burden. But we gladly take that challenge on, as Krista has indicated, because there is no greater pleasure than to serve your people.
My heart is so full when I hear people talking like this, and it's so again, thank you, Val and UVic, for letting us come together this way for this conversation. I'm going to turn to Christy's question. She says, I work in the field of climate change and would be interested in the panelists' comments on the implications of climate action for Indigenous law and rights, and how those working in the field like me can help to ensure that going forward, a better path is forged together. Hannah or Chief George Wilson, did you want to try and tackle that question?
How can she help? Sorry, can you say that again?
Climate action for Indigenous law and rights, and how those working in the field like me can help to ensure that going forward, a better path is forged together in relation to climate action.
I think on the climate action piece, that's all about what Indigenous people are doing in their communities. They need to be able to do what they think is appropriate, and how. I think they'll need help in how to do things. In addition to opposing a pipeline, we actually also have a solar panel project going on, and we've dabbled into figuring out this carbon sequestration things. I think that's what's really hard, is that when our communities are going to court, we're going to court because we're fighting against something really big that we're probably not going to win against, right? But what we need to do, like my younger sister always says, you need to flip it around. You need to think about something positive that we can do. Like, our people need to be considering what kind of alternate energy they can be creating in their own communities, whether it's running the river, or it's solar panels, or it's wind energy, or whatever it is. I think that's what our people need as well, to show us what is the alternate to whatever it is that we're fighting. But also, we need to be represented in a way that helps all of our people to understand what the point is to everything, or what the alternative can be, and how can we turn the alternative into something that we can live with. I don't know if any of that made sense, but I know it's things that we grapple with in our own community, and what to do, or where to go. And we don't always want to go to lawyers because not all of the lawyers are Indigenous or think like we do, which is why sometimes the NGOs are really helpful and useful when we need additional advice or information. Thank you.
Thank you. And I know we're running short on time. Hannah, did you want to add quickly to that? Because I know that's part of the work that you're doing at your organization.
Yeah, I would just briefly say that I really agree with what Chief George Wilson said about the need for, financial support and investments in alternatives to fossil fuel projects. I think that's critical. The other thing that we've been focusing on that I mentioned before is just as an environmental organization trying to ensure that the way that we're structuring the conversation is inclusive of different ways that people are approaching the challenge. And so just wanted to mention that Indigenous climate action, I think, has spent the last few years actually kind of doing work with Indigenous communities and understanding the way that different Indigenous communities are framing how they see the climate challenge, and that might not always even involve using the word climate. And so they're going to be launching the results of what they have found from those conversations, I think, in the coming months. And I know that we're going to be paying really close attention to what they found there, because we want to make sure that the conversations are being framed in a way that that knowledge and that perspective is not getting lost.
So I'm going to turn to the boss. Val, I know there's quite a few other questions, but I'm going to defer to you on how we manage the time with 3 minutes left, and if there's any in particular that you want to.
Yeah, thank you so much. Thank you all for taking those questions on, and for just bringing your minds and spirits and hearts to thinking deeply about what people are asking. So I think we do need to close, and let me just, to the people who've written in so many really important questions that are thought-provoking and which need much more conversation. Thank you for doing that. To our panelists, this has been an outstanding conversation, and I look forward to more of these conversations. And let's continue, and wherever we are, like, try and find and create spaces for these conversations. So we have at UVic, we have an online hub, and so there's opportunities to pose questions, to keep some of the conversation going. There's going to be a recording of this session, and it's going to be on YouTube. So there's a way to keep the profile, to keep the questions out there, and like through this and other means, like keep the space and the sharing that's going on. We really want and hope that people will continue to generate thinking, because we need the new thinking, and we can see how complex the field is. It's not about going back in time. It's not about simple answers. It's about being thoughtful and being principled and paying attention to history and to the present day, and starting the work with where people are at. There's also a survey on the hub, and we'd like to invite you to fill that out and share your thoughts about this panel, but also about the National Center for Indigenous Laws. This is a virtual concept that we're creating, that is connected to the addition that we're building to our law school, to our Indigenous Law degree program, to the Indigenous Law resource or research center that we have, and to all of this, bringing this together, but also to find ways for us to hold each other up. For Leah, for Kim, for Krista, for Scott, for Hannah, like all of the people online, that we hold each other up as we take on and continue the hard work that our ancestors started before us. So that concludes our time together, and thank you so much from my heart, and you've made you've made this just an amazing event. Thank you.
Hey, Scott, here's the love. Timmy Glitch.
Thanks, Val. Yep. Thanks, everyone.
Thanks.
Thanking all of you.
Have a good rest of the day, folks.
You guys were great. And Val, thank you so much for putting this together. You're amazing.
Oh, there's amazing
Such a
people.
good conversation.
We have good colleagues. We have John, Tracy, Al. We're so lucky. Sarah. Yeah. Okay.
All so much.
Bye, Hannah. Great to see you.
Here. See you, Hannah. All
Sorry
right.
we didn't get through all those questions, but
we never get through all the questions, Kim. It's just, you know, the questions are always an indicator of how important these things are. And some of them are really hard, and some of them are, you can see all the different emotions and so on that are there too, but at least they're started, you know, at least there's a space where people can think about what they want to say. And it's part of that long-term work of creating the grammar and language of Indigenous law, you know.
yeah. But I was reflecting, Val, on you know, when we were at the Truth and Reconciliation Commission, when we were taking statements, we didn't the statement gatherers didn't ask questions of the survivors other than two. There was two mandatory questions. One was around death in the school, if they knew where, if someone had died and where they might be buried, because as you know, that was one of the big things that the commission was trying to do. But the second question that every survivor that testified was asked was what they think about reconciliation. And so I always think it would be an interesting research to go through and look at the answers to that, because inevitably lots of people were like, had no idea what the term meant, you know, didn't know. And so when we brought the knowledge keepers together, it was like, what does that mean, reconciliation, in your language? And, you know, I just came off doing this policing panel in the last 2 years. And, you know, there was no language, there was no translation for police in many Indigenous communities. It was about peace. And so I often wonder what the language, what law is, right?
Yeah.
Like, if there's a word that means law, because when we met with elders about juries, they said, you know, there wasn't something called juries. There were people that were listeners, and they were called together to listen to speak to the individual who was, you know, not behaving the way they should have been. So it would be interesting to know what the translation would be in different languages.
It would be, you know, in Giksanamuk, that law is, it's ayok, and it means actually precedent. It means you draw on, and you bring forward the thinking. I was thinking as we were talking, I'll send around, would you be interested in, I just finished this IP report, Indigenous intellectual property, but it's two case studies looking at IP from within two different Indigenous legal orders. And it's just to try and shift the conversation away from state law, because that sucks up so much time and energy, right? And so, as you know, how do we have a conversation beyond that first, and then we talk to state law? So I'll send it along.
Okay, I think you sent me. I think you sent me last week when we were talking with Scott. You did send me something about the IP project, but
okay, maybe I already did.
Yeah,
yeah. Okay.
I haven't looked. I haven't had a chance to read it yet, but I'll definitely.
What?
You know, it's a pandemic here.
Yeah. All right.
Anyways, that was great. I was so pleased there were so many people in attendance. So.
Yeah, lots of people. Okay.
Yeah. Well, have
Thank
a
you.
nice afternoon.
And you too.
Nice to see you. Be well.
Take good care.